The Special Marriage Act deals with intercaste and interreligion marriages. Intercaste marriage is a marriage between people of two different castes. The days had gone by when people used to marry wherever their parents decided to blindly. The youth now have their own saying and choice and prefer to marry someone who is more compatible with them than marrying someone who belongs to their caste or religion. It is them who have to live for the whole of their life with their partner, and therefore, caste or religion is not a matter of utmost consideration now at all. Love is a beautiful emotion, and something like caste or religion should not weigh it up. All religions are equal, and marriage shouldn't be a big deal among them. We are conferred on caste or religion by birth and not by choice, so why are people of the lower castes seen with shame and disdain? India is a diverse country, and it is a pity to see things like this happening here. The Special Marriage Act is, therefore, a special law enacted to provide for a unique form of marriage by registration wherein the parties to the marriage do not have to renounce their religion. Applicability. This information is the most important for every Indian to know how they can use it. This act includes Hindus, Muslims, Christians, Sikhs, Jains, and Buddhists' marriages. This act applies to all Indian states, except Jammu and Kashmir. This act applies not only to Indian citizens who belong to different castes and religions but also to Indian nationals who live abroad. Requirements. Since Indians believe in marriages with proper rituals, customs, and ceremonies that include pomp and show and extravagant celebrations, none of them is required by the Special Marriage Act. The fundamental requirement under this act for a valid marriage is the consent of both parties to the marriage. If both parties to the marriage are willing to marry each other, that's enough. Caste, religion, race, etc. can't act as a barrier to their union here. For marriage under this act, the parties must file with the district's marriage registrar a notice stating their intention to marry each other, in which at least one of the parties to the marriage has lived for at least 30 days prior to the date on which such notice is filed. After the expiry of 30 days from the date that such notice was published, the marriage is then said to be solemnized. But if any person related to the parties objects to this marriage and the registrar finds that it is a reasonable cause of objection, on such grounds he can cancel the marriage. For a valid marriage, the parties must also give their consent to the marriage before the marriage officer and 3 witnesses. These are the basic requirements for a valid marriage under the Special Marriage Act that every Indian must know about. Conditions for marriage. For this special form of marriage, the conditions that must be followed are not very different from the requirements of other normal marriages that happen within the caste. These are the conditions to qualify for a marriage under this act. The bridegroom must be at least 21, and at the time of the marriage, the bride must be at least 18 years of age. This is the minimum age limit respectively for a boy, girl to marry. At the time of their marriage, both parties must be monogamous, that is, they must be unmarried and at that time should not have any living spouse. In order to be able to decide for themselves, the parties should be mentally fit, that is, they must be sane at the time of marriage. They should not be related to themselves through blood relationships, that is, they should not be subjected to prohibited relationships that otherwise act as a ground for dissolving their marriage.